My name is Kate O'Regan, for those of you who don't know me. I'm the new director of the even newer Bonavero Institute, and this is the fourth of our series of judicial conversations that we've held this term. I'm absolutely delighted, and we are enormously honoured to have with us Justice Dikgang Moseneke, who will be in conversation with Miles Jackson, a member of the university faculty here, and also a former law clerk from the Constitutional Court in South Africa. Tarun Kaitan, who was meant to have joined us, has unfortunately been taken ill, so Miles and I will just put the various questions that we've thought about to put to Justice Moseneke. The proceedings will be recorded and probably transcribed, just so that you're aware of that. And I'd like to introduce now Justice Moseneke. For many of you, I see many faces around the room for whom he needs very little introduction. He has had perhaps one of the most extraordinary lives of any judge who has ever sat on the bench. As a very young person at the age of 15, he was arrested and convicted effectively of trying to overthrow the apartheid state, and was sent as the youngest ever prisoner to Robben Island, where he was with many political prisoners for a period of 10 years. While he was on the island, he got a series of educational qualifications, and when he left, he commenced a career as a lawyer. He started off as an attorney's clerk in an attorney's firm in Pretoria, and in 1978 he was admitted as an attorney and then set up as a partner in the law firm which is well described in his recent book, Maluleke, Seriti and Moseneke. In 1983 he was called to the bar, and he practiced as an advocate in Johannesburg and Pretoria. I'm hoping he's going to tell us a little bit about that time this evening. 10 years later, he was elevated to the status of senior counsel and also served on the technical committee that drafted the interim constitution. In 1994, he was appointed deputy chairperson of the Independent Electoral Commission, which conducted the first democratic elections in South Africa. In September 1994, he accepted an acting appointment to the Transvaal Provincial Division of the Supreme Court, and almost sort of 5 or 6 years later, he was permanently appointed to the court, first to the High Court in Pretoria, and then in November 2001 to the Constitutional Court. He served a full term on the Constitutional Court, departing in May 2016. Shortly after the end of his term, he published the first volume of his autobiography, My Own Liberator, a memoir, which is a story of his early life, which I highly recommend. He tells me that he's working on the second volume of his autobiography at the moment. So the process this evening is a very informal conversation. Miles and I will participate in that, but we feel that if there are questions we put that you'd like to interrupt and would like to ask questions from the floor, please feel free to do so. We're going to sort of traverse over a whole array of issues, starting off with Justice Moseneke's early life and moving through to his jurisprudence on the Constitutional Court. So I'm going to start, Dikgang, if I may, by asking you a little bit about your early life story. You know, it is such an extraordinary story for a judge, and I wondered if you could tell us maybe just a little bit about those days when you were 15 and you got involved in the struggle and then ended up in a courtroom, perhaps for the first time.
Well, Kate, thank you so much, and thank you for having me.
It's a pleasure.
And I'm grateful also to the law school, as well as to the institute that also got me here. And at least I know you and Sandy, so the two of you. And that I've seen at least 3 former law clerks from the Constitutional Court here present. So it feels a little like home. And being in Oxford, I washed up, dressed up, and perfumed myself up so that I can present myself and avoid the stereotype of elephants and lions and giraffes and unkept people from Africa. So I hope I look the part.
We don't look very good dressed up in response, I'm sorry.
And Kate and I have a very special relationships. We were colleagues on the court for several years. So that connects us in a very special way about our country and its journey, which is quite a significant journey. It's always difficult and one is bashful to talk about oneself, and there you've put me on the spot again. It was easier to write about the experiences than to actually relate them orally. So if you bear with me, I'm going to be brief and run past that. I say this quite often in various audiences. It wasn't difficult to hate apartheid. And I talk often about the innate sense of unfairness in children. And if you're a grandparent like I am, you just test it quite easily. As I often say, I give grandchild 1 5 sweeties, and grandchild 3 2, and grandchild 2 7. So I give them these different numbers. My son is 3, my daughter is 3. And you'll hear the screams, "Grandpa, are you insane? This is unfair. It's told, why does she get 7 sweeties and I get 2? So you can't get away with being actually unfair with children, by and large. They have almost an inbuilt, innate sense of right and wrong. And mine was no different. I think by the time I was 12, Kate, I just hated what I saw around me. I started reading quite early because I grew up in a home of 2 teachers, 2 primary school teachers initially. So it was not overly difficult to build a sense of self quite quickly. And every time I moved from an African-only sort of living compound to one which was reserved for white people, I just hated it because it was conspicuously unequal. And there was a government at hand which obviously had the view that people were irrevocably different, and so different that they ought to be treated differently. And they thought it's their duty to entrench not only the difference, but the inequality. And that's really what apartheid was about. The misconceived notion that human beings are eternally and fundamentally different and don't deserve equal worth. So as a child, I just kicked back against that. And in no time I was attending student meetings. And in no time I joined a band liberation movement and was arrested, charged, and convicted in a trial which accused me and other students of trying to overthrow the government by violent means. Now, these were secondary school students, that's what I was to. Preceded by what? Solitary confinement, torture, an attempt to extract confessions, which frankly were something that many young people do right now, to talk about their dissatisfaction of just about any element of society. So there it was, and apartheid laws had a clear caveat. If you're convicted for an offense and your age does not come into reckoning for sentences. So they amended the Criminal Procedure Act to create that exclusion if you're convicted for one of these offenses. And these included sabotage, treason, being a member of a political party, Writers' Assemblies Act. So it was a carve-out. So you could send children to prison, and you're not obliged to have diversionary punishments. And that, Kate, that's the long and the short of it. Then I ended up on Robben Island at 15. And had to start fending for myself, essentially, intellectually, psychologically, in every other way to survive an ordeal, which is 15 years in prison in Robben Island. And in retrospect, it was short. If you think that Nelson Mandela had stayed nearly 3 times my term, and we're in the same prison, same place, so too all the other famous political prisoners of South Africa. So I had the privilege of being there. So too was Jacob Zuma, our president now. He was also on Robben Island at the same time. But I could go on and on and on with Mac Maharaj and Ahmed Kathrada. Dennis Goldberg. There came apartheid, was kept in a prison separate from our prison because he was classified white. So apartheid cut through Bram Fischer was kept separate because he was classified white. So apartheid really, as we often say, from the cradle to the grave, and it had a geography that sought to keep people separate, different, and unequal. So even in prison, indeed, they made sure that it was applicable. And prejudice alone is one thing, but if it's enacted into law and public goods are divvied on the basis of how you look, race was the one level, gender. There was massive gender inequality in South Africa. And the society was patriarchal. There was a blanket exclusion of all sorts of choices, legitimate choices that people make. Sexual orientation, religion. I mean, the school was supposed to be Christian education, which excluded so many just by the appellation and the tag you placed on education. But I could go on and on and on. There were marriages and marriages and marriages, and you had to marry only in the one way for yours to be a marriage. As for the rest, the law would attach no consequences. So it wasn't difficult, therefore, to be a young revolutionary.
No, but it had consequences. When did you decide to become a lawyer?
On Robben Island, as you know, I studied first a BA, and I thought I was going to study, I studied English and politics, English literature and politics. That was predictable. As I told you, I started reading quite early as a young person, and there were books in the house, so I thought, well, I'll do, after matric, I'll do literature. And when I wrote matric on Robben Island, remember, and there were sad books which I read very quickly. Typical colonial sad books, Jane Austen, Charlotte Bronte, the complete works of Keats, Wordsworth, name it. The saving grace from time to time would be J.B. Yeats and T.S. Eliot, which would really save you from the drudgery of this, middle of the road English literature, which you had to gobble up and for you to pass. So that I did very quickly and went over it. What it did was to tell me that there's much, much more there and better, I suppose. And so I had an interest in literature. But the university offered pretty much the same thing. First year, second year, up to a major. Third year, Chaucer. In Africa, in Tunisia, you had to study Chaucer and the complete works of Shakespeare. You had to do 3 tragedies and 3 comedies, and I don't know what else in the middle. But that triggered, as you know, I say about in the book, me going out to go and look for Dostoevsky, Crime and Punishment, to go and look for War and Peace, Tolstoy, to go and look for Grapes of Wrath, Steinbeck. And suddenly then I was drifting away to more progressive kind of literature that would talk to what we were on Robben Island. And as I was reading, I thought, this is what I'm going to do. I'll probably lecture in literature. And Chinua Achebe, and I started reading very progressive writers, both in novel and otherwise. But once I'd done that, I thought, how do I use this in the liberation and the transition of our country? And I thought law was a more obvious avenue to do that. And then I registered after the BA, then I registered for a B Juris. As you know, Kate, for very quaint reasons, they didn't allow prisoners on Robben Island to do postgraduate work. Like Ahmed Kathrada, you could do 5 junior degrees, but not so. So in that way, yes. Then I decided to do law. And then I was quite committed to the course. I thought this is what I would do. And then did an LLB, which I completed just when I came out of Robben Island. Yeah.
So, go ahead, Marcel.
And I wonder if I can pick up there and ask what
Yes.
it was like to be a lawyer in the late 1970s and 1980s in the system, where the law is ahead of time against your cause, but you're using it in particular ways.
Yeah, you'll remember, I write a lot about it in my memoir, and it forms a rump, at least, of the legal practice at the time. The conflict was the one ever present, which really is, if you are an activist in society, you want to see the society different from the one that you operate in as a lawyer. The question constantly is, do you resort to the law? Or do you find more revolutionary means to change that society? And at what point do you make the decision that this is not good enough? And a typical example would be Bram Fischer, a very outstanding lawyer, who hits a point where he says, I cannot move this awful beast by using rules. I have to do something more than this. And that is to join an active liberation struggle to try and transform it. So the obvious thing once I qualified as an attorney was to be, if you like, an ambulance of the struggle. There are going to be casualties on the way. People are going to be detained. Many disappeared in detention. Many communities were moved forcibly in order to create the apartheid geography, which really was, you are there, we are here, and the twain never meet. So the idea was, and therefore they were moving people and communities forcibly and impoverishing them in that process. And we would, as lawyers, would resist the process. And you really would do it in a formalistic way. They haven't given due notice. Or, notice was too short, the notice was effective, but you would, within parliamentary sovereignty, you would have a law, but you'd pick at its size and its formal requirements to try and give people relief. So we all understood that we were tinkering with with something that was pretty bad. Surprisingly, it worked. Look at the PAS system. Cases like the courts or like, all of those were not, yes, they're not going to change the core of a hideous system where you had to have your identity document on you all the time. And it can be demanded, you have to produce it on demand. And failure to do so would be an offense that subjects you to immediate and summary arrest. So you could not change, but you could actually go every time go and look at the formal requirements. And our apartheid minders were very formalistic. They liked the rules they'd made. So they didn't like them being breached unduly, even if it were to favor oppressed people. So we did that by and large. Another one important thing was the habeas corpus proceedings to produce people who have disappeared. And that protected people, it protected lives. Pleadings in capital punishments, I write about that. Saving people from being executed. When there's a lawyer, there's a bigger chance that you won't be executed than when there's not. So that was a role, and it never was fundamentally the sense of changing the system, but it certainly lessened the burden. And we all understood that that was the dilemma of lawyering in an unjust society.
So in the early 1990s, you became involved in the process of constitution making. And there's a growing debate in South Africa, I think, about that process. What's your sense, looking back, on how inclusive that process was or how constrained that process was?
Yes, Kate, there's a deeper discussion going on, and I'm sure we're going to talk about it a little even tomorrow, about whether the process that Nelson Mandela and F.W. de Klerk initiated was any good, to use plain language. And the skepticism, I think, arises from the inefficacy, the ultimate inefficacy of the transition. We can talk about that a little later, but young people see the transition as having done nothing to change their lives, and everything to favor those who were already privileged. In other words, alternatively, it took away nothing from those who were privileged, and yet gave nothing to those who were disadvantaged. So, Cape Town come as a ready example. Langa Nyanga Kukuletu look pretty much the same. And if you like, Constantia, Bishop's Court, whatever else, looks very much the same, if not better. So it's very difficult to argue that the transition served the purpose it was intended. I think that's where it is. But going back to the real question you're asking, the process, I think the process was beneficial. I still stand by it. I think in the book I draw attention to some of the omissions of the process. And I think the biggest omission was the negotiations being completely silent about the how in equalizing society. You know, the kind of debate that people are hankering for now is the one that did not happen in 1994 in a serious way. The debate was drenching about, for instance, how to change the jurisprudence, how public power will be deployed, the parameters of a democracy, architecture of the state, fundamental rights and freedoms. So those things were important. But there's no discussion about how do you make society more equal. My immediate argument is that, of course, nothing in the Constitution prevents a democratic government from getting on with the job and doing the right thing, even up to now. If anything, you know, you can see it from our jurisprudence, your jurisprudence, our jurisprudence. Ours was meant to be a transformative constitution. It was meant to change society and not to tinker around. That is why we have the notion, for instance, of substantive equality. And that is why we've insisted that just about everything must be looked through the prism of the values of the Constitution. And what has remained, many argue, is the rigor of the Constitution on legality, on the rule of law. And yet, not much is done around measures around substantive equality. And that criticism, of course, is growing day by day as the government is becoming less efficient, as the government becoming, well, efficacious or effective, whatever the word is. Yeah. The more the misgovernance, the more young people feel this was a neoliberal pet bargain which has gone bad, and it had to go bad. So it's quite a momentum building around this issue.
So
go ahead.
So if you say there's nothing in the Constitution now that would prevent a democratic government from pushing forward transformation, I wonder if you're thinking back to the drafting, are there things that might have been put into the Constitution as the institutional design or political apportionment that might have pushed things along. So if you can look back to that moment in 1992, 93, when you're negotiating, it may be that nothing's stopping it, but are there flaws that you would redo?
Yeah, if you might or might not remember, after 20 years, I wrote an article, which some people call seminal, in which I was asked, what are the 4 things that you would do differently in the Constitution? And you can Google quickly, you'll see that article. It was at Misra where I delivered it. Misra is a think tank of rather progressive thinkers and public intellectuals who invited me to come and talk there. And I singled out 4 things. The first and obvious is the one I've just said, that we should have had a direct discussion about the how in procuring substantive equality in society. And that becomes important if you think that the preceding 300 years of devastation, of exclusion, of hatred, of oppression, of impoverishment, of dispossession, that's what colonial experience was. Of low skills, of non-participation in the economy, that's what apartheid did, it's those things, those hideous things. A few of us escaped, almost like escaped slaves from the system. We beat the system, but it took so much to beat the system. You had to go out there and graft and work hard and keep intact your sense of self. So that was the first one. The second one, I said, we had underworked the provisions that regulate land. And that even with the provisions of Section 25 as they are, we could have achieved so much more. And I spent a lot of time to draw out and pull out the treasury of land restitution, how 1994 the statute was passed, and they've done nothing. The statistics show administrative bungle up and the government preferring to settle it with cash. And we know with a lot of corruption and kickbacks and going to farmers and offering them twice the amount so that half of it get kicked back to them. So they never really got down to pushing restitution in the way conceived by Section 25(7) of the Constitution. And I go and draw attention to the provisions of the Constitution, the power to expropriate, the power to afford security of tenure, where the tenure is tenuous. Granting people greater tenure, for instance, on farms, because there's then wholesale sort of throwing out of people from farms and so on. And the government's power of expropriation, provided it's for public purposes. And then to be obliged to pay compensation. In the article, I draw attention to the fact that there's no such thing as willing buyer, willing seller. The law doesn't require the seller to be willing, nor does it require the government to be a buyer. The government could expropriate. If it were to, the owner of the property could agree to that in the sense of agreeing a price, but could not resist only because he or she doesn't want to sell. That wouldn't be a valid defense, because the law gives the state the power to expropriate. All that would remain would be a debate of compensation, which the law requires to be fair compensation, not market value. And fair, the Constitution sets out 6, 7 factors you'd have regard to when you determine what is fair. When was it acquired? How was it acquired? What was state help and support in the acquisition? Is the land currently in use? You add up all of those and decide what you pay. If there's a difference, the state, the courts would settle that dispute. By the time I left the court, by the time you left the court, the state had not expropriated even once, at least in a way that led to a dispute. Now, terrain so hotly contested, it's shocking that, it's surprising that there was no dispute whatsoever that ended up in the courts. And the reason is that the state bureaucrats went out to farmers, gave little offers, and made all sorts of deals, and just never got down to the job. And lastly, in the paper, of course, I draw attention to the fact that the state owns a lot of land. One of the big gifts of the transition in 1994 was that the state automatically inherited, the new state inherited all the land of the old state. To this day, they don't have a land register. They haven't done a land audit.
State land. Yeah.
So they don't know what land they own. Now, state enterprises also traditionally owned a lot of land. The railways. 5 kilometers side by side of every railway line, that land would belong to the state. Transmission lines of electricity, so many kilometers, those tracts of land would belong to the state. Telecommunications, so the state, besides it, the provinces, the local government, what is the extent of that land? Which of it is available to meet land hunger? And I drew attention to that nothing had been done, and truly so. If they'd done most of that, we wouldn't be having all this. There's no real excuse to have people live in squalid circumstances in the Perry Evans, whether in Cape Town or Pretoria, anywhere else. When the state can take, I don't care how big a loan it is from, I don't care where, World Bank, wherever, and use it for capital investment and build infrastructure and bring water and sewage and water to the people, build streets and roads, and we're going to kickstart the economy. They talk about it every year, but they don't do it. There's land, there are resources, there's no effective government to do that. And frankly, if those things were done, we would be in a much better place. And so in short, I don't think the Constitution stands in the way, properly understood and interpreted, stands in the way of very radical change of people's lives at the instance or the encouragement of the state.
So, turning now to kind of more complex, or the closer questions of the relationship between courts and government. South Africa is no exception in constitutional democracies to have given rise to tensions, very overt and sometimes not so overt tensions between the elected branches of government and courts. You've written important judgments on this question of the separation of powers. Is it possible for you to give us a brief sketch of how you understand the role of courts under the Constitution, what the proper role is, and how we should understand that?
Thanks, Kate. For once, I'm now talking law and not politics. The judge, which I am, I thought I'd escape somehow, but the two are fairly intertwined, and the question shows it. Well, I heard Mr. Trump talk about overreach within the first week of his role in office. And our president, currently the NC, has been screaming quite in nasty terms about overreach. When I wrote many of the judgments that I did, you remember, talking about a counter-revolutionary judge who peddles neoliberal notions of jurisprudence. Now, you know me, far be it from me to be accused of that, but I've had that accusation, even that, and the court generally. When we inducted our new constitution, one of the critical questions we had to answer was who would be the referee once we'd done the usual thing of parceling out power, public power. In the UK, you did it more silently. In the rest of the world, we did it volubly. We wrote it down in our constitution and we said, here are the powers of the president. The third question I wrote about, by the way. And we ended up creating an imperial president, unwittingly. Here are the powers of parliament. And primarily to make laws, to pass and regulate budgets, to approve budgets, in other words, in appropriation bills, and to hold the executive to account, and lastly, to debate matters of public importance. So the key four powers of parliament sit in there. And as usual, judicial power separated and was said to reside in the courts. But we did more than most constitutions do in our case, and that was, in so many words, we said, we inducted constitutional sovereignty and said every law or conduct is subservient to the Constitution. In a very simple language, you say any law or conduct inconsistent with the Constitution is invalid. Now that's a far-reaching line. In that very line, we really created judicial review that is expansive. Every law or conduct inconsistent with the Constitution. And by application, and then we inducted the judiciary, it will determine what's a constitutional matter, and it will decide whether the Constitution has been breached or not. So as we did that, we installed the judiciary as the referee that will blow and see whether it's an offside, whether it's a try, whether it's a whatever it is. And as we did that, in fact, we inducted what today is complained of by many young activists and young intellectuals as a judiciocracy of sorts, ruled by the judiciary. Over the years, as you know, Kate, in the first court, the court has been very careful to say which matters are properly justiciable. But by and large, the outcome was every public power is subject to the control of the Constitution. Pharmaceuticals. That really meant that there is no exercise of public power that is immune from judicial scrutiny. And in order not to overreach, Kate, you'll remember we introduced levels of scrutiny. We didn't go the American route of strict scrutiny, but what we did, we used really two principal standards. Rationality was the one, which is the lightest of the lot, and of course reasonableness. But in none of those, we said, may the judiciary replace its preference for that of the executive or the decision maker. So we're at pains to draw that line. And also as a matter of comity, just plain respect amongst wielders of public power. But we were the ones who were going to draw the lines about what don't we want to reach. And at varying times, people have complained about whether or not we have gone too far. Probably the farthest I have seen was the recent order of a High Court judge that the President produced the record on which he decided to reshuffle cabinet. If you ask me, I would have made an order like that. I would have, certainly not after writing my settler,
Yes, I was thinking of Mosetla when I read that. So maybe we should just fill people in. Mosetla was a decision written by Dikgang, which was a case about the head of the intelligence services, and the former president, President Mbeki, fired the head of the intelligence services, said he had lost the relationship between them had broken down irretrievably, and he was therefore terminating his employment. And that decision was challenged in the court on the grounds of mostly of procedural fairness, that Mosetla was entitled to a hearing. And Justice Moseneke wrote a decision saying, no, in these circumstances, this is a person the president is entitled to have confidence in, and requirements of procedural fairness are not required. And I concurred in the judgment. But there was a dissent. There was somebody who thought that there ought to be procedural fairness.
Yeah.
And, in many ways, it is very similar to this recent decision, which has gone about the question of shuffling cabinet, in particular the removal of the former Minister of Finance, and whether that decision can be subjected to review in any way by the courts. I think the decision in relation to the order to produce the record is actually on appeal. So we will obviously see with interest what happens there.
See where it comes to, yeah. There are things, our reading of the Constitution, Kate, has always been, there are certain decisions which are immunized. You cannot possibly tell a president or a prime minister or a foreign minister, in your case, why they've appointed A as ambassador in Argentina, or why they've constituted the cabinet the way they have. And if you're entitled to see the reasons, then by implication you're entitled to examine whether they are good or bad. And I think that's a terrain where, short of outright malice or short of total corruption or something, if he says, I want so-and-so as head of intelligence, I think judges ought to back off. I mean that is my view or my understanding of, because the idea was to allow, he must produce the results politically, he must be able to constitute a cabinet, and he must be able to reshuffle the cabinet. That he does it in an impolitic way, or in a way that prejudices the country, is neither here nor there.
It's this business of trying to draw a line, isn't it, between the legitimate terrain of law and the legitimate terrain of politics.
Yes.
And some areas you say this in fact is a terrain for politics, and the sanctions are political and they're not legal.
Absolutely.
Yeah.
And I'm sorry.
I wonder if I can pick up on that and ask if you think that line, whether the separation of powers doctrine is fluid, and by that I mean it does or ought to change depending on how, say, Parliament is operating. So if Parliament is calling the executive to account through committees, the court might restrain itself. Or if you think that is not something the court should take into account.
It's a good point you're making. You're really saying, if the system's failure, ought the line to be drawn at a different place? And I don't know what the answer is. If I had the court, I would have been a little more, in something that I wrote, I think you had just left in Mazibuko. Were you still there, or you just left the court? Mazibuko was a case where the opposition came to court and said, the speaker doesn't want to entertain and place on the order of proceedings a motion of no confidence in the president.
Yeah.
And the speaker took the view that, no, I have a discretion in the matter. And you cannot, like I have in other matters, what comes on the order of proceedings is not there for the taking because you want it. And she refused to set it down, and they came to court and were required to interpret the provisions of the Constitution that entitle every member to basically table a motion of no confidence. And she said, no. The Constitution doesn't mean that. You must go through the proceedings committee. There's a committee that vets what comes before Parliament. And in that committee, the ruling party had a majority and refused to have the motion set down. I wrote with the concurrence, it's actually unanimous judgment. I wrote and said, No, it wasn't unanimous. I think Mogoeng actually dissented. I wrote and said, no, you can't do that. You can't use procedural preconditions to frustrate a right the Constitution confers. So the Constitution will always enjoy precedence and held for the opposition. So there, the democratic wish of the majority was one that set itself firmly against constitutional provision properly understood. And I had no difficulty in embracing, assuming jurisdiction and saying, you can't do that. You can defeat the motion of no confidence in the voting, but you cannot defeat it even before it's tabled. That's so where you draw the line as a judge ought to be constant, I think, ordinarily. The fact that South Africa finds itself in a political quandary is no reason to want to review cabinet reshuffling. I think that's going far. Even with Parliament is dysfunctional to some degree. They're incapable of resolving conflict inside Parliament. And they've rushed to court quite frequently. So next question you might want to ask. That they come to court so often, is that reason to shift the line? In e-tolls, as you know, I refused to shift the line. I said, no. You invited the court to decide whether it's fuel levy or it's tolls. And that's a decision that judges ought not to make. It's truly polycentric. It's truly budgetary. And they put up reasons for the fuel levy not being appropriate. I wasn't persuaded, but that was not my call. So I exercised restraint and said, that's not my call. Whether they use fuel levy, and if the Minister of Finance and the Treasury and them filed affidavits to say we thought about it. And we don't want people in the Cape to pay for tolls in Gauteng because they get no benefit out of that. And yet petrol levy runs nationally. I thought this was a reason good enough, and it was not irrational, and refused to uphold the e-toll challenge.
So in a way, picking that up, do you think there's something in that critique that opposition parties, once you get in the habit of winning in court, they run to court on everything? And did you ever as a judge think, perhaps you can't say as what you're thinking as a judge, but this is not a matter for you to approach us about, this is a matter to march about or to argue in Parliament about?
Yes, I mean, it has been increasingly difficult, Kate, ever since you left, I think. It has become increasingly difficult because, opposition parties leave Parliament all the time and come to us. Under our constitutional arrangement, it's not difficult to formulate a dispute that's justiciable. Excuse me, pardon me. And Section 34 of our Constitution, you all remember who worked on the South African Constitution, entitles anyone who has a dispute that is capable of resolution by the application of law to have a right of access to court. So 34 was never intended to be so broad. But when I look at it now, Kate, as a second thought, and experientially, it is a broad provision.
In many ways, it's been one of the sweeping provisions. So if you look at the number of cases that have been brought under Section 34, it is one of the most litigated provisions in the Constitution. It's just about right of access to courts. Certainly in 1994-95, we did not expect that. And I wonder whether it's got something to do with the fact that both lawyers and courts understand access to courts and so therefore often formulate things in that way. But it really is interesting how much litigation is developed.
Yeah. when it was drawn initially, certainly it was not intended to be that, but it's a right of access to courts. And this is related to our past in apartheid. Courts were not readily accessible. Remember that they made a law that if you're detained under 90 days, the detention is not susceptible to judicial review at all. So the state parliament could make a law and say, this is not reviewable. This tax in rate, blah, 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 is not. So we wanted to make sure that a new government does not come, a totalitarian government cannot keep people out of courts. That's what 34 was intended to do. And now, every political problem is clothed in legal terms, and we don't have a political question doctrine like the Americans have. So the courts have to do with deciding whether or not they actually want to engage that particular issue.
Yeah, go ahead, Abby.
Just on this point, may I ask just a follow-up question on this standing provision? So I can really see why the Constitution would have set the standing rules in a broad way, given the history that you described. And given that history, the rationale would be to make the courts open, to make the state vulnerable to the claims of individuals. But it seems to me that that rationale doesn't transfer to opposition parties, powerful politicians, oil companies, and so on. So was there a decision early on that, whether consciously or unconsciously, opened the standing provision to these type of special litigants and unwittingly led to this kind of legalization of, you know, parliamentary procedure, which is anathema here? You know, just no court would accept this. It would be absolutely barred constitutionally.
Interesting point. Justice Reagan, as she was then, wrote a very interesting judgment, which I quote from time to time. I'll remember the name in a moment. And she says, when you want to bring class action or action for a group, you must show that it's a serious intention to act for the group, for the club. You cannot randomly take something from there. Now, political parties never have an issue themselves. They always act for the public. No, it was not Kalame Rich, it was, I'll remember it in a moment.
Ferreira.
It is Ferreira Levine. Yes, it is Ferreira Levine. And so you cannot merely wake up one morning and say, hey, I want to do this, you know, whatever it might be, you know. So there is a test, quite a stringent test he set out on when you fall within a suit brought in the public interest. And you examine the nature of the interest and its seriousness, and whether it accrue to the benefit of the public truly, or only to your mates or a few other people you like, and so on. So it's so we did try and rein it in, but nobody quite foresaw that the words, you have a right, you know, to come before a tribunal or a court on any dispute that is justiciable by application of the law, that's broad, and therefore, if I were in the court still, I would certainly be pulling it back. The problem has been that the government has been so inept that opposition parties have won just about every single case they've brought. I mean, take something like Nkandla, which is, I shouldn't say Nkandla, I should say Nkandla. So I should call it the right way. As the president complains about people going, Nkandla. Okay. Now, if you take the homestead of the president, just built for like $250 million, 250 million rand. Or even here, it could be 20 million pounds. It's supposedly here it's a lot of money. If you had to build that for a prime minister, to his or her exclusive benefit, that would be a lot of money out of the public purse. Parliament could have reined that thing in quite early, isn't it? Parliament could have pulled him up and said, you haven't shown why you're entitled to this kind of benefit out of it fiscally. They just did not do it. At the beginning, the Minister of Public Works could have done it. Sorry, Mr. President, I'm not approving this because the funds were in his portfolio. And later on, I mean, none of them really did it and ended up in our court. And it went right through the court. So there is a bit of impatience with, I think, also abusing process. And both are doing it. The ruling party is doing it. The president does it more than many, most certainly. And the ruling parties, every time they have fared well with costs against the state. So, yes, you're right. This time has come to basically revisit 34 and interpret it much, much more narrowly and placing strictures that will prevent abuse, I think.
I wonder if I can shift a little bit to one thing we talked about in the previous two seminars is the experience of the judge in judging, background experiences. I know I'm putting you on the spot, but I wonder if there are just cases where you think your experience has affected how you saw a case, where your colleagues might not have seen it, or where they saw a case differently from you because of experiences or background issues in their background that then led you to reconsider or think about it again.
Well, yes. I mean, the answer must surely be yes. I mean, many, many years ago, I think the realists have written about the inarticulate premise and how we judge is inevitably are influenced, even if it's unconsciously, about this inarticulate premise. When I write about, for instance, equality, I can't pretend that I've not been affected by my hatred of inequality and exclusion and apartheid and racism, sexism, patriarchy, excluding people with sexual orientation only for that reason, or religion. Any of those things were hateful in apartheid. So you can expect that when I write, the first side of patriarchy, I'm going to send it off banging away. Even if it's in tribute to my mother, who was the greatest activist that I know on women's rights. So I must concede that comes in. And if you go and troll my judgments, I'm sure you'll see a deep hatred for inequality, for racism, for those things. That, and as I interpret the provisions, I suspect that will intrude. But on the other hand, think about it. If I had a dissent with Kate in all the years we served together, there are probably 2 or 3. And yet our experiences are very different. And our upbringings and so on, though they converge at some point when you join forces that resisted apartheid. And yet we agreed on many, many points. So the fact that 11 is an antidote against subjectivity, I think. And probably 90% of the judgments I wrote that high were unanimous. If I had differences, it was mainly with more than anybody else on the court. And I saw some statistics that showed that I differed with him more than any other justice of our court. So I'm afraid no, it works well, you debate well, and people show you a blind spot, and sometimes by way of dissenting judge or concurrences. If you look at a case like Barnett, there's a concurrence there that points to matters which I had not reached. And which were, there's a unanimous judgment, but the concurrence goes to where I had not gone. And where probably I was reluctant to go. And they said, well, we agree with you, Froneman and Cameron justices. And they went there and wrote to tease out the potential hurt that might come out of restitutionary measures if not carefully applied. Something I say too, but in ampersand, and they spend a bit of time on it, and all that is helpful. But by and large, I think our court produces unanimous judgment far more than it produces a Glenister, which is on the knife edge.
Can we talk about Glenister? Because, as we mentioned to you in our kind of proposed questions to you, there are really kind of three core issues, and you've talked about one of them. One is the need to undo the dreadful legacy of apartheid colonialism, and what the court can do about that, and what the Constitution can do about that. The second is on the land issue, which is a very specific aspect of that. And then the third is on the question of corruption. And in some ways we've touched on the first two, but we haven't touched on Glenister. And it was one of the judgments that was issued shortly after I left the court, so I didn't participate in it. And I wonder if you could talk about whether you think that this was a decision that was a stretch, in other words, from a legal perspective. Because, just to fill people in, Glenister was a decision which took the view that under the Bill of Rights, there was a right to be protected from corruption, which imposed an obligation, although that's not actually explicit in the Constitution, and that that imposed an obligation upon government to ensure that there is an agency that is independent of government in seeking to oppose corruption, and reviewed an agency that had been set up by government in replacement for a previous agency, and took the view that it wasn't sufficiently independent. An outcome which, as a founder member of Corruption Watch, I heartily applauded. But I just wondered whether you thought, I wondered firstly perhaps whether you think this might be a quiet aspect of our Constitution to add to your four, something that we perhaps didn't foresee strongly enough in the mid-1990s, the risk of corruption, and so therefore it may be an area where the Constitution is silent and we should have thought more carefully about it. And secondly, and it comes back to a point that Miles put to you a little earlier, that there are times where a court has to do something that may be legally a stretch, but which is in fact very important to protecting the overall framework of the Constitution. And I wondered what your responses are on that.
Yes, the Colombian court comes to mind when you think about a bit of water.
Yes, of course.
Thank you.
We actually had Judge Sepedi here just 2 weeks ago to
Oh,
talk about the
really?
Colombian court. Yes, exactly. So very timely that you should mention
Sure.
it.
I'm trying to wiggle an invitation so that I can go and look at them more closely.
I'm sure they'd be delighted.
It's one of the courts I admire, and I've just come back from doing what you did earlier. I was in New York for 5 weeks,
Right.
doing the stints that you normally do if you have been off the court and you get invited. So I came here just a week and a half after NYU Law School, where I stayed much longer than here. And there was one Colombian activist and lawyer who was present there, who gave me this wonderful book, and I promised I'd go there one time. The Glenister occurred just at the beginning of an era that was to become so horrible in our land. A new president had come into power and urged on parliaments to pass a law that basically repealed an earlier law that established a corruption fighting unit called Scorpio. And it's shown to sting in many ways because that's successful, that's a good successful record. And the record shows that before the court. But by majority, Parliament passed a law which scrapped all of those powers, and in particular the powers that rendered the corruption-busting unit free from political influence. And the question was whether that legislation is constitutionally compliant. Erin Cameron and I collaborated in writing Glenister. People always ask wherever I go, I think I know which parts you've written, Moseneke, and I think I know which parts Cameron have written. Well, I say, well, take your guess. Please do, every day take your guess. And with long, hard debate with Edwin over and over again. And in particular was Kate about how we use international law in order to make clear the implicit duty of the state to fight corruption. And to that extent, I think Ngobo CJ, as he was then, misunderstood our judgment entirely. He thought we say, because international law has a deep distaste for corruption, look at all of these conventions which are corruption, that trumps domestic law. We hardly said that. We were saying, you're obliged to look at international law, look at what it says, look at its provisions on the kind of institution you need in order to fight corruption. You must read Section 7 and the rest of the other rights in the Constitution with the understanding, with the backdrop of international law that requires countries to fight corruption. There is an obligation on us if it is not domesticated, and yet it's sufficiently authoritative to look at in understanding the rights, provisions, and jurisprudence of our country. And the heart of it was, you could hardly suggest that the right to dignity tolerates corruption. The right to access to any of those social goods is tolerant of misuse of public funds. So properly understood, the rights include a deep distaste for corrupt conduct, and in fact imposes a positive duty on the state to erect entities that would fight corruption. So it is one that already exists. The state may not take away its teeth, its fangs, in order to water it down in a way that it can't fight corruption. And we concluded it was obvious that the law does not prevent political influence on the corruption fighting entity. Yes, people say it's a stretch. They say, my goodness, that is long legal reasoning. Indeed, it was long.
Sometimes you have to stretch.
Sometimes you have to stretch, that's the question. And sometimes I have to stretch. Firstly, I will defend the judgment and say, no, it flows inevitably from the structure of our Constitution. Because you cannot possibly say our Constitution is neutral on corruption. How could you ever say that? And that's why we begin right at the beginning with how deleterious and destructive corruption is. And we could not have given birth to a constitution within which permits that to happen. And then we go on, of course, to look at other provisions to buttress that argument. The other side, the dissent said, you have elevated international law to our own law in a way that is impermissible. You may not do it, and the features are sufficient, particularly if Parliament chooses them to be so. That was the other side. And of course the court was split, basically 6-5 on it. 4-5, we were 9. We said 9, I think it was 4-5. And the current Chief Justice Mogoeng and Nobo and one or two other people, Zaki Yakub and others went along with a 4. And after a few whiskeys, he told me he thought his decision was wrong. But either as it may, we had 5-4 into judgment, much debated, much criticized, and supported by many also. Stretch, I think you should, but in extraordinary circumstances and with great care, I think. And as a bare minimum, the accountability, judicial accountability, requires of you to explain yourself fully. And that's what the judgment tries to do. And to lay bare the reasoning in a way which somebody can say, I don't agree with it, as people some say, or I agree with it. Or it's a stretch, implying that ordinarily you wouldn't have reached where you did.
And if you were drafting Chapter 9 today, would you add into Chapter 9 some independent institution in addition to the public protector that had powers to really investigate and pursue corruption in the light of what we now know?
Yes, I would. I mean, we left it to statute, but we never anticipated that we would get to where we are. Just the other day I was talking with the Western Cape, and I was talking about this false exceptionalism that we had.
Yeah.
The belief that we were somehow superhuman, and that the ordinary foibles of societies in transition would not be visited upon us. And with a Nelson Mandela, you cannot but feel that you're going to be angelic in the way you live your lives, and our democracy would be. And we won't have pilfering members of parliament, or stealing presidents, or lying presidents, or when I was in New York, there was much talk about post-truth society. And questions were asked whether there is a comparison between our president and the American president.
You're going to tell us what you said.
I see I'm being recorded, so I'm going to stop right there and pause right there.
Well, I think that's been a fascinating array of questions and comments, and thank you very much for it. But I know that there are lots of people here who've got great expertise in South Africa and who've probably got a whole range of questions. So I think we might turn over to the floor, and we might go on to a kind of Chatham House rules basis as well. Steve, we can pause recording here.